Hi, I'm Cassandra with the Home Advisors team with Keller Williams Realty, and today I'm here with
Reid. I'm the managing partner at Reid, Maloney & Link, a law firm here in Lakeland. We specialize in estate planning, trust administration and probate, real estate, and employment law.
Okay, and what got you into real estate planning?
So my background was in law school, or the class load that I took in law school was fairly intensive on real estate and on estate planning. I took I earned a JD certificate in real estate law, and then I took some LLM courses, which is like a master's degree in taxation, to get a sense of the tax planning. Because even before I started practicing, I realized that those two things are going to often come in hand. So if you're doing estate planning, you're going to need to understand these real estate issues, and really vice versa.
So how often do you see real estate come into play with estate planning?
Virtually in any case that I have. So I frequently have, my primary practice is planning. I do some administration, but really I'm probably just in my heart, and what I really enjoy doing is planning. And as I'm doing planning for people, it is very uncommon for me to run into an estate where there's not at least the possibility that real estate's going to be involved.
Why is real estate such a crucial part of estate planning?
So understanding real estate and how title works within an estate plan is a really important part. If we don't take that into account, and I just say create somebody a will, my concern would be that if the real estate is not titled correctly, we could have to do a lot of extra work when the person dies, and that could make the estate plan not work as efficiently or as well as what we had originally planned.
So what's one thing people don't realize about how their home is handled when they pass away?
So that's a great question. I think the titling is what I would really focus on in answering that question. I think people don't realize that the way you hold real estate has a lot to do with what happens to it when you pass away. I'll give you an example. If we had a husband and wife, and maybe only the husband had the property in that person's name, I think the assumption would be, and oftentimes people are under the impression that if that husband dies, that property is going to automatically go to the wife. That's not necessarily the case. And to analyze that, we would need to look at what's the family situation on both sides of that marriage, and just how is it titled, and that can really make a big difference in how that's going to play out when the person dies. It could very well be that a surviving spouse still has to go through probate, where you could usually avoid that.
Oh, wow. And that's the way that they take title when they purchase the property.
That is exactly right. So, we typically are recommending that married couples take property as we call it, tenants by the entirety here in Florida, and that's an estate that is kind of an ideal estate to own property in as a married couple, because you're going to it has some creditor protection qualities to it. It also has survivorship among the spouses. So no matter which spouse dies first, the surviving spouse is taken care of. And so you really have some nice features to that that work very well along with Florida's homestead, which is a whole other set of rules that can be really helpful.
So who determines how title is taken when you purchase a property?
It really is up to the buyer.
Okay.
But frequently I think the buyer doesn't know that they have any choice in the matter. So that's a question that it is certainly fair game to talk to your realtor about, talk to your title company or the lawyer's office that's closing the deal. Those are all any of those people, if they're aware that you have questions about it, can help you figure out how to make sure that when it's closed, it's actually set up the way you would like to have it. Now, it is possible in that scenario that the person who is doing the closing might not be able to give you legal advice, and you may have to seek that advice from somebody else. And a good title company is going to say that if they're not representing you, if it's not a lawyer's office, they're going to say, hey, you probably need to get some advice on that. And so a lot of answers to questions are going to be, you should talk with your lawyer. And that's not just because I work with a law office.
So now we're going to talk about wills and trusts. So what's the difference between a will and a trust when it comes to real estate?
That's also a great question, and I think in order to answer that question, I'm gonna take that back a step and talk a little bit about probate, because the reason we do trusts has to do with probate. So when a person passes away and they have property that's just in their name at the time of their death, that property is going to have to go through a process called probate. Probate is not the end of the world. It's kind of a negative sounding word. People often think of it as a negative thing. And it can be, but it also can be well planned. So probate itself is not necessarily a bad thing. However, when we're dealing with real estate, oftentimes timing and making sure that a deal can come together and have the timing on that work for the parties, in terms of maybe there's not enough money there to sustain the property for a time after mom and dad pass away or something along those lines. When those kinds of circumstances happen, whether that has to go through probate or not can have a really big impact. So probate is a fairly lengthy process. In most probates, not all probates, but most probates, you're going to be looking at least 5 months of activity before it's completely done. Usually property can come through a probate through various means. There's a lot of variables here, but can come through probate in a 3-month time frame to maybe 4 months. And because you're having to wait that long, a lot of people prefer not to have to go through probate the time of their death. Of course, the person who passes away isn't going to have to experience that, but it's going to be the heirs that come after them. So a solution to that problem is to put property and accounts and things like that into a trust, and the trust is going to avoid probate, because with a trust, and when you have property that's titled in the name of a trust, it's not going to be titled in your name, therefore it doesn't trigger that requirement for probating. And so now you've got a fairly private enterprise where you've got a situation where the person can, a successor trustee that's named in that trust instrument can step in, take over the assets, and just make that next thing happen, whether that's selling the house or setting it aside for a child that needs to still live there, or any of those kinds of things.
And when you put your property, your homestead property, in a trust, does that affect your homestead exemption?
No, and that's a really good question, because it would seem like maybe that would have an impact there. But in fact, there is a Florida statute that says that provided that the right language is in that trust, it is possible for a trust to own homestead property without jeopardizing that homestead exemption, including any sort of reset that might happen in value. So it really is a neutral transfer when you make that transfer from yourself into a revocable trust. Again, these things are, I'm giving you general principles, and I would say anytime you deal with this kind of stuff, you're going to want to get a competent attorney to help you navigate those waters.
Well, I can definitely see the value in that, as there's a lot of details that go into the way that the property is deeded and the language you must have in a trust to make sure that what you want to have happen happens. And so what is your feeling about, people doing it themselves essentially with online resources and not hiring a competent attorney?
That's a really good point that you're making there. It is a very important thing, I think, to get advice in those situations. There are some elements of that a person can do themselves. The problem is there are pieces of that process, drafting the trust, recording and preparing the deed. Those are all activities of practice of law, and you really do need to have that law license to be able to do those things. And so the concern I would have with somebody trying to do all of that themselves is you might have the lawyer do this little piece over here, and then you're trying to do these other pieces over here, and really if it doesn't all come, it just makes it much more likely that something is going to go wrong. So it's very important, I think, to understand whether your circumstances are right for a trust, whether it's something that would actually really beneficial. The answer to that is not always yes, but is often yes. It's a really, as you've been pointing out, it's a really great way to pass property, and specifically with real estate can be a really handy way to pass title. But it is something that it's a good idea to have somebody evaluate the big picture of your circumstances to make sure that that's done correctly.
It's not a one-size-fits-all.
No, that's exactly right. That's well said.
So if someone has a will, what happens to their real estate when they pass away?
So with a will, the will, in order to be effective, has to be probated. you can have an interesting situation where if you are, if it's a husband and wife who own property together and one spouse dies and there's a will, you don't necessarily need to probate that property. It might just pass to the surviving spouse because it's titled the correct way. But if there was, say, a single person or a surviving spouse survived by, say, children, which is a really common situation that we run into, adult children, that property is going to have to go through probate in order to pass to the next generation. And so you're going to have that will probated, and the will is going to say who is going to get what. In the absence of a will, you would have to rely on Florida law, and there's actually a statute that's an order of how those things descend to the next generation.
So even if someone has a will, that doesn't avoid probate.
It does not. And in fact, that is a really common misunderstanding. People think, I have a will, I'm not going to need probate because my will is simple and it's easy to understand. That's really not the issue. The issue is that in order for a will to get carried out, you have to have a court appoint the person who's going to be in charge. Call that person the personal representative. That can, again, there are situations where that process is very helpful, but a lot of times it's avoidable, and if it's well planned, you can avoid it and still have a really manageable situation. And so that's a lot of what an estate planning attorney would do in a situation like that, is try to look for ways where we can help pass property from one generation to another in a way that just manages those circumstances and just makes that as straightforward for those who come after as possible. Putting real estate in a trust can really make a lot of sense. If the property is held in in a person's name, the concern would be that even if you have a will, that's going to have to go through probate. And so having it go to a trust and held in a trust during your lifetime can really make that easy. There's some circumstances where it really makes sense. So as an example, if you have somebody that you intend to live in the property after the person passes away, if that person wants to say provide that house for a child who is older but maybe not old enough to live elsewhere, or just simply is living with the family because it's a convenience for everybody. That kind of situation, a trust can be a nice way to not have a lot of movement in the title of the property and keep it steady while that person lives there. And you can put constraints in the will of how long that goes on and when it gets sold and things like that. And so there's some nice ways that you can control what happens. I try to encourage people not to go too wild with trying to control what happens from the grave, because of course we want to let our kids live their lives and things. But on the other hand, it can be a really helpful way that you can structure that gift and make it really work for the next person. So, but its main property with the trust, the main thing it does is avoids probate. That's its main feature.
Can someone have both a will and a trust, and how do they work together?
Sure, that's a great question, and that's something that often throws people for a loop. So somebody comes and sits down with me, and we talk about a trust, and we decide that the trust is the right tool for them, and then we're almost done with the conversation, and then I bring up the fact that we're going to need a will, and the person's like, wait a minute, I didn't think we were going to need a will. Here I have a trust. Why would I need a will? Well, you still could conceivably need a will, because if there is a debt that might create a problem for the estate, or if there is sometimes we'll have cases where there's a lawsuit pending of some sort. Either the person who died was suing somebody or was being sued by somebody. In order to take part in that litigation, we're going to have to open probate and have somebody appointed to represent the deceased person. Those things can be complicated enough as it is. If you don't have the will there's no way to really, there is an order of events that happens in the statute, but we really don't want to rely on that. We want to say inside of a will, here's who we would want to be in charge, here's how we'd want you to deal with it. Usually with a trust, if we do a will, we're doing a thing called a pour-over will, which just means that anything is in the estate, it's going to come back into the trust after the probate's done. So it just makes sure that if, say, we did a trust and we missed something, say there was a bank account that you opened in 1997 and it's been a while since you thought about it, and you forgot to put that in your trust, the pour over will is a way to get it out of the person's name and into that trust so it can be administered.
To help finalize the estate.
Exactly. So just one more thing you might have to do there. So if you own property and you were to pass away and have no planning at all, there's no will, there's no trust, nothing to say what would happen, the first thing that we'd have to do would be to look at how that property is titled. If it's titled in just your name, then we're going to have what's called an intestate estate. That just means it's a probate with no will. So when you do a probate where there's no will, you're going to have to follow this series of rules that's laid out in the Florida statutes that says who's going to be in charge and how that property is going to descend to the next generation. So there is a whole laundry list, it's actually called the intestacy statute. There's a whole laundry list of heirs that would inherit, and that can change depending on your situation. For example, somebody who is divorced, that can affect who impacts, or excuse me, that can affect who inherits under that situation. So those are things that really suggest that a will would be helpful in those situations, and that it's probably not a good idea to just rely on those default rules. Could you do that? Yes, but it's probably not a good idea in most cases.
Big question. Are there any tax advantages to placing real estate in a trust?
So as much as I would like to say yes, there really aren't any specific tax advantages to doing that. So I'll tell you why that is, and then I'll give you some tax good news. So on one hand, by placing a property in a trust and then having that descend, say, to your adult children, that is something that has a set of tax consequences that really is the same whether you have it in the trust or whether you owned it in your own name. It doesn't really matter from a tax standpoint how you were to pass that. That's called a testamentary transfer. The good news with that is that when you inherit property, you get what's called a step up in tax basis, and that is a very significant advantage to the beneficiaries. So as an example, if I were to gift property to somebody during my lifetime, and then that person sold the property, when they sell it, they're going to have to pay tax on that sale. And we're assuming right now, let's take out the primary residence because there's an exclusion there, which will muddy the waters here. But in this example, so this is a house, and let's say I bought that house for $100,000, and then I gave it away to my good friend who was so nice to me, and so then they turned around and sold the house, and they sold it for $300,000. So they're going to have to pay tax on that $200,000 differential because they're going to take my tax basis because I gave it to them. There's no change in the basis. If they purchased it from me, that's going to change the basis. But in this scenario, when we're talking about inheritance, if that person inherited the property from me, they're going to take the value of the property at the date of my death, which means that if I own that property for 20 years or 30 years or 40 years, and there's a lot of appreciation in that property, all that appreciation is going to go to the beneficiaries and none of that's going to be taxed. They're only going to pay taxation on the appreciation that happens in the property after the sale. Now there is, just like I say, it's a good idea to consult with, lawyers to make sure that you know all the specifics, because I'm speaking in real generalities. Right. It's definitely a good idea to get your tax professional involved in that discussion as well, just to make sure you understand that. But these are definitely things that should be discussed when you're talking about your estate plan.
So what is a transfer on death deed, and how does that work?
So a transfer on death deed is actually not, we don't call it that in Florida.
Okay.
So what you usually hear, Florida, their version of the transfer on death deed is typically called either a life estate deed, an enhanced life estate deed, or a ladybird deed. And I'll talk about one and then it'll help me explain the other. So a life estate deed would be a deed where, and I'll use myself as an example. If I wanted to deed property to, my child when I passed away, and I didn't want to have to go through probate, and I didn't want, a trust might be too complicated for my estate, I might create this enhanced life estate deed. What that would do is it would give my child a future interest in my property, and it would allow me to live in the property during my lifetime. The problem with that type of deed, just the straight life estate deed, is that if I change my mind later on, I'm sort of stuck. Oh. And so I'm paying the expenses of this house and I want to sell it. I'm got to go ask my child for permission, which I don't want to do. And most people wouldn't want to have to ask for permission from the person that they're going to give property to have to transfer it. You can see why that is, right? And so with the enhanced life estate deed, what we do is add powers to the deed so that if I change my mind later on, I can undo that deed. I can put it back in my name, or I can choose a different remainderman, or any of those kind of things. But no matter how I do it, it still has that probate avoidance quality. And that's why I would ever go to the trouble of doing that. That is another alternative to using a trust to pass property. Sometimes the ladybird deed is a good idea. That's just a slang for an enhanced life estate deed. Sometimes that ladybird deed is a good idea. Sometimes the trust is a better fit, and that's something it's a good idea to get advice on which one is is the best way to go about avoiding probate.
So if I already own the property, can I change the deed to a ladybird deed?
Yes.
Okay.
Yeah, absolutely. You're able to do that. Again, it's a good idea to enlist a professional to actually prepare the deed for you. But assuming that was what you're going to do, the only thing you need to be careful of is if your property has a mortgage on it. So so like for instance, if I have I want to put a property in a trust, and if there is a mortgage on that property, I might use a little bit different technique to get that property into the trust than I would if it's a free and clear thing, or if it's, if the property is free and clear of that mortgage. The reason for that is most mortgages have what's called a due on sale clause, and that due on sale clause says when I transfer that property, it's going to become the mortgage is due. Now, is the mortgage company going to enforce that? Maybe not, but you might not want to rely on that.
Yeah.
And so we want to be a little bit careful there. Again, that's a good place where it's good to get advice and just be a little bit careful. But assuming you own the property without any kind of encumbrance or mortgage, transferring that property either to a life estate deed or to a trust, all of that's possible.
So what are some common mistakes people make when they try to leave their house to their kids?
That is a thing I see all the time. And the call that I get is, I want to leave my house to my kids. So the way I want you, attorney, to help me do that is I want you to put the kid's name on that property. And that is a way you could do that. You could create a situation where, and again, I'll use myself as an example. Let's say I wanted to give my house to one of my kids. I could put that child's name on the title, and I could say as joint tenants with a right of survivorship. Now we're assuming in this example that I'm not survived by a spouse, because that would create some other issues. But because certainly I think my spouse would be mad at me if I was just leaving property to my kid that actually she owns half of. But assuming that that's not the scenario, I'm going to put that house in a property and say it's joint tenants with the right of survivorship. That would cause that property to pass to my child when I passed away without any need for probate. And here's why I generally don't like those kinds of deeds, or generally don't advise that as a way to transfer property. And there might be a scenario where I might, but in general I don't love those kinds of transfers for two reasons. One is I've now given my child control of my property. I've actually got more than two reasons. I've got, control is one reason. Another reason is we might be in a scenario where it causes me to lose a portion of my homestead exemption if I make that transfer. Another thing has to do with the beneficiary and how this property is going to benefit them. If they inherit it that way, they are going to get less of a step up in tax basis when I do it that way, because they're only inheriting half. One half of that deed is a gift, and the other half happens at my death, which means I'm now cutting those tax benefits in half. And it really doesn't give them any more or less than they would have had. If my goal is to make that happen when I die, that's usually how we want to do that. So that's one that I am concerned with. The other thing is people doing deeds themselves without seeking advice at all. I have seen some horrible situations that involve people muddying up their title to their property by doing, quit claim deeds. And a quit claim deed is, it's a technique. It's something that can be used to fix a problem or to correct an error on a deed or to deed something you're not exactly sure whether you own all of it or not. There are situations where those kinds of deeds make sense, but it's definitely not something that I recommend that people try to do on their own, because the attorney may need to do a title search. They may need to look at a few different things to make sure that we're not going to create more problems by trying to solve one problem.
Yeah.
Yeah.
It's too easy to miss one number or one letter, and then you've got a cloud on the title that you have to fix because of one little mistake on a deed.
Exactly.
Leave it to the professionals.
Exactly. I think it really is the prudent thing to do.
Yeah. Can you explain how joint tenancy works and how that differs from a trust?
So there's actually a couple of different types of joint tenancies, and joint tenancies are created by deeds that go to multiple people. So the most common one that you see is going to be a thing called tenancy by the entireties. That's a way in Florida and a couple of other states where you can own property and it's an inseverable estate, meaning that that husband and wife, they own that property together. And for instance, if one of them got sued, they wouldn't be able to levy against that property because they own that in that kind of special way. That is only available to husbands and wives, though.
Okay.
And so that's kind of a unique joint tenancy. There's also joint tenants with a right of survivorship, where two people who aren't husband and wife might own property and have rights of survivorship. And then you have a thing called tenancy in common. And tenancy in common is where each person owns the property and their estate would own the property if they died. So as an example, if my son Evan and I owned property together and we had that as tenancy in common, if something happened to me, my share would go to my heirs, whoever they are, whatever my will or my trust says, and then if he passed, his would go to his heirs. And so it would have the potential to spread out among numerous people, and that's why those are typically not really desirable. There are situations where we might use a tenancy in common, but they're not always a very desirable estate. When you use a trust, in contrast to a joint tenancy, you are putting all of the things that make the property pass to the next generation in one document. You're going to have one thing you have to read and look at and determine what needs to be done. But then if the trust is well drafted, it's going to spell out exactly what's going to happen. And I think part of the reason a trust is such a clever device and such a useful tool is sometimes what people want to do with property is rather specific. They might want it to go to this family member for a time and then pass to this family member over here when that first family member dies. And those kinds of things are things that are really easy to do with a trust, much harder to do with a deed.
So what should blended families know about passing down real estate?
So with a blended family, the planning for passing real estate and really any other asset that you own becomes really important, because there are some default rules that happen with a person when they have a second marriage. So as for an example, if you had property that was owned by the husband in a husband and wife situation, and the husband were to pass away, and the property was in that husband's name, and the husband were to be survived by children from a prior marriage and their spouse, you might think what would happen would be everything would go to the spouse because that's his closest person. Or you might think that everything would go to his biological children.
Right.
But in fact, what would happen is everything is going to be divided in equal shares between his spouse and any children of his, whether they are of the first marriage and or the second marriage. And so that can create now that might be exactly what the person wanted to have happen, but if it's not, that can create some really unusual, unintended consequences. And probably some of the messiest probate administrations I've been involved with have had to do with intestacy, where there's no will or no trust or no other planning that's been done, and a blended family where now we have property passing to people that were not originally intended to have it passed to.
Interesting.
Yeah.
So we've been talking a lot about homestead property. So what if I have a second home or investment property? Can that be put into a trust?
So yes, you can put A lot of different things in a trust. Trusts are very flexible. Something that people don't often are surprised to hear when I talk to them about it in estate planning meetings, you can put a company in a trust. If you owned, let's say I was a real estate investor and I owned some LLCs and I went out and I bought these properties and I put them in my company for liability purposes, we can actually have those LLCs in turn owned by a trust. This is, again, something you wouldn't want to, this is something that it would be a good idea to get advice on, but it is definitely possible to do. But I also sometimes see people own properties just in a trust that are investment properties just directly without the imposition of a company. Homestead can be owned by a trust. And then there is also, and this is probably really another topic, but I'll mention it, is land trust. There is actually a slightly different kind of trust that people can own specific property in. It's mostly a tool that relates to anonymity and trying to sort of not disclose in the public records who owns that property. And so that is another type of way that somebody can own property using a trust. But to me, the most common ways that or at least in my practice, what I mostly see is if we're using a revocable trust, we're going to try to use it for as many different things as we can to make good, you took the time and energy to create this trust and to, put everything in place, that we want to use that as comprehensively as possible.
Would there be any reason someone would need multiple trusts?
You would. It is a little unusual, but as an example, if you have somebody who's got some potential for estate taxes, that's of course today becoming a little less likely, because right now a single person would have to have, well, it'll be next year, these numbers will be accurate, but will have to have about $15 million in their estate before they pay estate tax. And so for a husband and wife, that would be about $30 million before they pay the first dollar of estate tax. So it's becoming less common. It's not that I haven't ever seen it, but it is not nearly as common as it used to be when the exclusion amount was $1 million. You had a lot of people that fit into that category. So, there might be examples where you might have a revocable trust, which is what we've been talking about today, to hold property and other things. And then there might be, if there's a need to get property out of a person's estate, we might use another type of trust called an irrevocable trust to do that. There also is a technique called we call it an ILIT, or an irrevocable life insurance trust, is another way that you could take property out of that person's estate, or simply be able to pay into an irrevocable trust in a way that would allow assets to grow in that trust. So that irrevocable life insurance trust, the thing it owns, as the name suggests, is life insurance. And so then that life insurance would grow, if there's investments in the life insurance, it might grow inside that trust. Any growth there is not counted in the estate of the grantor. So there's some really neat things that you can do with trusts, and kind of dividing up a person's estate and making sure that we're just efficiently passing that to the next generation. And also there are some times where trusts are used to even benefit the person during their lifetime, to pay income and things like that. So, and incapacity planning is another, great use of a trust. So very flexible and useful documents for sure.
What should a homeowner consider before they put their home in a trust?
That's a great question, and you might think that the first thing we'd look at is the real estate, but in fact, one of the things that we ought to probably do before we advise whether a property should go into trust or not is to maybe back up a minute and look at the big picture of that person's estate. What else does the person own? Do they have investments? Do they have companies? Do they have other things that might be useful to have a trust involved in? And if a trust can solve more than one issue in that person's estate, then it really starts to make more sense. Because there are less expensive ways to pass property outside of probate, but they're not as comprehensive. So, we can use as an example an enhanced life estate deed to pass property outside of probate, but that only solves one problem. And if you have other property we need to avoid it, it might be better to just have one instrument that's a comprehensive approach and just takes your whole estate outside of probate. So so then what we do once we've kind of determined that a trust is a good approach, Then we dig into, okay, how can we interact? How can we have the real estate interact with this trust? Do we want to have it held now? Do we want to have it pass to somebody else at the time of your death, or pass to the trust at the time of your death? Those kinds of things are going to be part of that conversation.
If your home is in a trust, how does a refinance affect that?
So financing is an important thing to take into account with a trust. I mentioned in our conversation a little while ago that, there are these due on sale clauses that are found in mortgages. And so that tells you that they don't really want you just transferring this to any person. A trust really is not a transfer in the sense of changing beneficial owners, because when you put property into a revocable trust, it's really just you putting property in a way that is still completely controlled by you. I usually urge a little bit of caution in how we approach that, and I have a technique that I try to use when I'm working with a client to kind of decide how we want to handle that issue. But then when it comes to refinancing, sometimes that can actually resolve the issue. Because if I have my house let's say I purchased the house in my name, and at some point I decided to roll the dice and put the property in a trust, and my bank never got upset with me, but then I went back to them and said, okay, now I want to refinance. When I go to refinance, they may say, look, we're fine with you having your property in the trust, but we might want to put the loan in the trust as well.
Okay.
Just retitle the loan in the trust. So it'll be relevant, but it shouldn't really impact whether or not you can do a refinance. I have in one instance had a company say to a client, and I didn't do the original deed, but they had deeded property into the trust, and the bank said, no, you've got to take it back out. And it really was pretty easy though, because all we're doing when we're putting property into a trust, we're just deeding into the trust. So we said, okay, bank, if that's what you need so we can refinance, we took the property back out of the trust, put it in the person's name, and then came up with another way to get it into the trust at the time of their passing.
So can a trust be used to protect from creditors or lawsuits?
So there are types of trusts that can be used for that purpose. And sometimes we see trusts combined with other planning techniques in order to create that asset protection quality. But revocable living trust, which is usually the type of trust that we will use for an estate plan, those types of trusts really don't have any creditor protection qualities.
Okay.
So we're going to have to think through that. But the good news of that is when you're dealing with real estate, there may already be some that you're not even aware of. As an example, your homestead property is probably about as safe an investment as you can have, because that property is exempt from creditors in general. Obviously, things like your mortgage company for the mortgage that you used to buy the house, they're going to be able to attack that if you don't pay the mortgage. But things like, if I'm in an automobile accident and somebody gets a judgment against me, they can't levy that against my house. They can't force me to move out of my house so they can sell the house and satisfy that judgment. That's not something you can do under Florida law. And Florida is quite unique in that respect, and really has some of the most consumer-friendly homestead laws of any state in the country. It's really quite remarkable. There are also other ways, if I had property that wasn't homestead that I could protect. As an example, I could put a property into an LLC and title it that way, and then have that LLC held by my trust.
Okay.
So I can still use the trust, but it's not the trust itself that creates the asset protection.
So what if someone decides to do a DIY estate planning, write their own will, and they forget to include their home?
So the non-inclusion of a property in a will is not necessarily fatal. There is a thing in most wills called a residuary clause that would say, here is what happens with anything I didn't specifically name. And so it is possible that in this DIY will there is such a clause in there and that it is properly drafted. But there's a lot of ifs in that sentence, and I would not recommend relying on that. I understand and see the need for kind of less expensive alternatives to estate planning. So I understand that there is a market out there for things like LegalZoom and other products like that, and I understand why people are drawn to that. The argument that I would make to people is, this is generally not a recurring expense. This is something you're going to spend money on one significant time, and then you may have some, ongoing cost, every 5 or 6 years to come and, have your estate updated and make sure, or just have somebody review it to make sure that it's adequate. But that little bit of additional cost, what you're going to get there, if you are hiring somebody who does estate planning, somebody whose main practice is estate planning, and I do recommend that people work with planners who really, that's mostly what they do, because it is a somewhat complicated area of the law. When you do that, that person is really going to help you to see things about your estate you may not have thought about, ask questions that are about circumstances you may not have ever dreamed of. And so those kinds of things are really why you need an estate planning attorney involved. That person can help you look at it in a much more objective way and kind of think in a little bit different way about your assets. And as an estate planning attorney, one of the things I really enjoy is having that conversation and seeing kind of the light bulb go on for people, and see that they have a real sense of peace when they're done with it, because they know, okay, I've really covered the waterfront. I've really thought about everything that that a person can reasonably think of. It's hard to think of everything, but with help, it can be a much better product and a much better experience for those you leave behind. So I think it's really important there. And particularly with real estate, because how you title things has to match up with the will or the trust or whatever the instrument that you're using to plan your estate. And so even that disconnect can create problems. And so having an experienced attorney help you along those things, help along with those things, is going to be, I think, incredibly valuable.
Well, it sounds like it's an investment for the future of your heirs.
That's exactly right. And it's also a way that they can, really understand that you cared enough to do that for them. That it's just another way, just like when you set that money aside in the account for the child because you really want them to, know that you were thinking about them throughout your life. This is another way you can really show people that, hey, I had that there is a thoughtfulness in kind of thinking through these issues and helping the person understand what they're receiving and the value of it. And that can be really important.
How can a trust help prevent a family dispute over property?
So families will often get in disputes over property when things are not clear. That can be a big thing. So if the child has an expectation that something is going to happen a certain way and it doesn't, that can sometimes create problems. The other way is if there is not a way for the child to know what the parent's plan is. And it's the one shortcoming of planning through things. Well, there's actually more than one shortcoming, but it is a shortcoming of planning using things like pay on death beneficiaries and deed techniques that cause the property to just go directly to the child. One of the downsides of that is there's nothing that says what the parent actually wanted to have happen. And so that can sometimes create some confusion as to how are we supposed to handle this? If you just deeded us the property, was your intent that we sold it? Or was your intent that we were going to keep this property? And so in that sense, if there needs to be a more managed experience because of maybe kids that are inexperienced or kids who are, anxious, we have that happen sometimes where, heirs are just anxious because they've never had to deal with property. So having a trust can really help you spell that out. Oftentimes I really encourage people to be flexible in their trusts and to allow for different things to happen, but it can still be helpful to just have that guidance. And then the other thing is, because you're administering the trust, typically that person is going to get an attorney involved, and then the attorney is going to help kind of shepherd that process as well. So there's two ways where you can really, it doesn't necessarily always avoid the dispute, but can sometimes soften it or take some of the air out of it because there's information there. And I think generally those things happen because people don't know what they're supposed to do or what was supposed to happen.
What is one thing every homeowner should do today to protect their property?
First thing I would do as a homeowner is to look at your deed, see how that property is titled, And if you're not sure how that property is going to descend if something happens to you, go contact your estate planning attorney and talk to them about what you might be able to do with that.
Or contact you.
Or contact me.
When should someone update their estate plan, especially regarding real estate?
So when there are changes in your real estate holdings, that's probably a good time to visit with your estate planning attorney. But if there are no significant changes, I recommend not letting more than about 3 or 4 years go by without, just checking in. And most attorneys are, if they're going to charge you anything, they're not going to charge you a lot to sit down with you, go over your will, and just discern what might need to be changed.
Make sure it's up to date. All your wishes are the same.
Exactly.
Nothing has changed.
Exactly.
Okay. So as a real estate agent, what would be your top tip for me when I'm talking to clients about wills and trusts?
The main thing is to make sure, especially when they're thinking of buying real property, is to think about how they want that property to be titled. And if they're not sure, it's a good idea for them to talk with an estate planning attorney to just determine what's the best way right up at the beginning to get that property titled so that you have less work to do later on.
Andy, thank you so much for all of your information you provided today. I've learned a lot about wills, trusts, the way you take title in real estate. How would someone contact you if they want to set up a consult or learn more?
Best way to contact us is to call at 863-687-1771 and ask to set up an appointment with one of our estate planning attorneys.